Tabitha, are you talking? I can't hear you.
Yes, can you hear me now?
Now I can. Now I can.
Oh, okay, good. Do you want to swear me in first?
I do. If you want to raise your right hand and affirm under penalty of perjury under the laws of the state of Washington that all evidence you give in this proceeding shall be the truth.
I swear.
Proceed.
Okay. So this case concerns Bethel Citizens Committee for School Support, which is a political committee that the PDC is alleging that they violated RCW 4217A, 235, and 240 by failing to timely and accurately file C3 reports and C4 reports disclosing contributions and expenditures undertaken by the committee and provide required expenditure details on C4 reports for election year 2022 that were due to be filed from 2019 to 2022. The respondent is registered as a continuing political committee. They registered on October 13th of 2021 for election year 2022, and they selected the full reporting option and indicated their support for a Bethel School District 403 levy, bond, or advisory vote to be determined in a 2022 special election. The committee registration or C1 report was amended on August 18th of 2022 to update the committee's contact information and change their treasurer of record. And that is Exhibit 1 in your packet, Commissioner. It should be noted. Sorry. It should be noted.
I read it.
Oh,
I read all of the exhibits.
Oh, thank you very much. Okay. It should be noted that they were previously registered for election year 2019 to support a different ballot proposition. As a result, both the 2019 and 2022 committees filed reports for 2019. So I wanted to make sure you understood that. Late reporting by the 2019 committee was addressed in a previous enforcement action, and that was PDC case 111247, and therefore that is not included in today's scope of today's case. However, late reporting for the 2022 committee that occurred from 19 to 2022 is addressed here. Pursuant to RCW 4217A, 235, and 240, a committee that selects the full reporting option on their C1 report is required to file reports of contributions and expenditures to the PDC, and the due dates for the reports are based on the election cycle, the committee's election participation, and their financial activity. I did find out that the Bethel School District did have ballot propositions placed before voters in 2022. There were actually 4 of them. 2 were rejected and 2 were approved. I did attempt to confirm with the respondent their participation in the elections. I reached out to them a number of times. However, to date, they have not provided that information. So that's purely...
The invoices that were submitted regarding the texting, didn't that support the concept that they were participating because of the time of those invoices?
There was some overlap. So some of the expenditures look like they could have been for February or April. And I was trying to confirm because that would impact what they needed to file. But because they haven't been forthcoming with any information, it's a little bit difficult to say. I wasn't able to confirm, which exactly, because they had multiple text message expenditures, and it's unclear which election they were for, but there were 2 very close together in 2022. So that is part of the challenge today, Commissioner, is that I'm operating on incomplete information. I realize this is a very lengthy memorandum, but I'm trying to give you as much information as possible to make a decision.
I appreciate your work on that.
Yeah. Let's see. I did provide an attachment of the key reporting dates for you so that you had that. Right. I did open this case on August 30th of 2023 based on a complaint filed by Glenn Morgan. He alleged the committee failed to timely and accurately file C3 reports and C4 reports and provide expenditure details on C4 reports that were due from 2018 to 2022. And of course, 2018 is outside the statute of limitations now, so and actually part of 19. So I've made a little note there. They did respond initially to the complaint on October 5th of 2023. They did apologize for the delay. The treasurer said she had just taken over the task of filing their reports, had trouble logging in and submitting reports, and provided some personal reasons why there was a delay, and indicated that she'd be bringing the reports up to date within the next couple of weeks. And that was, again, that was in October of 2023, and that's Exhibit 4. There were a series of attempts to reach out to them and provide filer assistance help, and they responded saying they were going to be working on it and that they would reach out to the PDC if they had any issues. I wasn't able to find any indication that that occurred. And then I sent information in November asking them to amend some reports. That has not been done. There was a case status review held on November 20th of 2023. They didn't attend the hearing. And that was because the case was going to exceed the 90-day attempt to resolve within 90 days. So we had to hold an initial review. And after the initial hearing, I did get an email from the treasurer saying she wasn't able to attend because of her work hours. But that was after the hearing had been held. And then I reached out to them again on May 28th of 2024, June 7th of 2024, July 9th of 2024, just reminding them that we still needed those amendments. We expressed concern that no reports had been filed. I think the last files reported were in August of 2022. I'm not seeing any progress on the reporting.
Sure.
So I reminded them that we were available to help, that these reports needed to be taken care of. Then on July 17th of 2024, the committee's treasurer responded to my July 9th email, again, apologized for the delay. She did indicate she's been on FMLA due to a severe illness and has a stressful new job. She didn't indicate how long that had been the case, and you know, as you can see, this case has been open for a while, but she did indicate she planned to contact a firm to start filing the committee's reports and would let us know when that had happened. That's exhibit number 5. I did email the respondent on July 29th to inquire whether the firm had been secured and when they expected to have that accomplished. Then on August 6th and 7th of 2024, I served the respondent by mail and email with a hearing notice for today's brief enforcement hearing. And it was concerning their failure to timely file C3 and C4 reports, amend expenditure descriptions, and I sent that to their email address of record and their mailing address of record. Then on August 28th of 2024, I emailed the respondent again a detailed list of missing C4 reports. I went through every report and identified all the C4 reports that were missing for which C3 reports had been filed. So they reported contributions, but didn't put them on C4 reports where it also shows expenditures and that kind of information. So I sent them a detailed list of what was missing. I did email them to take care of that before today's hearing. And basically, in short, what needs to be corrected is we need them to file missing C4 reports disclosing $22,803.82 worth of contributions that were deposited in 2019, 2020, and 2022, and a $90.40 reimbursement that was received in 2022 for a canceled service. And I did let them know they could file a single C4 report for each year. So instead of filing a monthly report for each month, they can file a single C4 report just to get that information disclosed properly. And then they also need to amend 4 monthly C4 reports, 2 pre-election C4 reports, 1 C3 report for 2021 and 2022 to disclose contributions totaling $5,702.51, and make 2 corrections to reports and amend 6 C4 reports for 2021 and 2022 that lack expenditure descriptions. So that's, in a nutshell, what we need from them. So I've got reports that are missing altogether, Commissioner, and then also reports that need to be amended. And then as of August 30th of 2024, and I looked again today, despite multiple requests, they have not filed or amended any C3 or C4 reports, and they hadn't accessed their ORCA account for election year 2022 since August 15th of 2022. I'm not able to locate any written record showing they have reached out to ask for help. Of the reports that were filed for election year 2022, the following were late. There was a 21-day pre-special election C4 report for 2022 that was 52 days late. It was filed after the special election and disclosed $337.70 in election-related expenditures. There was a 7-day pre-election C4 report for 2022 that was 63 days late, filed after the special election, disclosing $2,830.58 in election-related expenditures. There was a post-special election C4 report for 2022 that was filed 26 days late, disclosing $2,054.50 in election-related expenditures, including some political advertising. There was a monthly report for March of 2022 that was 126 days late and filed after the April special election that did disclose $3,980.91 in election-related expenditures, including political advertising. And then 4 monthly C4 reports for 2022 were filed 5 to 97 days late, one of which contained at least $773.26 in election-related expenditures. There was one late monthly C4 report for July that was late, but it was mitigated because there was a lack of activity. It was a $0 report. And there were 9 late C3 reports for 2019, 2020, and 2021 that were filed between 217 and 899 days late. So again, those are the ones that were filed, but they were filed late, and some of them were after the election to which they pertained. So there are a number of mitigating and aggravating factors and that can be applied when resolving minor violations. The respondent's treasurer did report she's been on FMLA due to severe illness, and then the campaign does appear to be relatively small or unsophisticated. Potential mitigating factor, I haven't been able to confirm this yet, but it's just unclear if they are experiencing any technical issues that are frustrating compliance. Like I said, they haven't reached out to tell us they need help. I've offered multiple times, so I don't know if that's an issue. Then an aggravating factor would be the non-compliance concerning pre-election reports, because those did deprive the public of timely information during a time-sensitive period prior to the 2022 special elections. And then another potential aggravating factor is if the reports are not filed by the date of the hearing, and that does still appear to be the case. I checked this morning and I don't see any reports have been filed. And then they do have one prior occasion of a violation of 235 and 240 that occurred outside our 5-year statute of limitations. That was resolved on October 28th of 2022, and they submitted a signed statement of understanding and a $150 penalty for that violation. And they also, the remainder of it was resolved with a formal written warning letter, and that's Exhibit 7. So there is that prior. I will say that the late reports for election year 2022 were filed prior to the SOU being signed and the warning letter, so they didn't violate the warning letter. So this isn't a case of them violating the prior, but it is an aggravating factor. So then I want to remind you that that you can, excuse me, let me go back. If you find that they violated 235 and 240 today, it would constitute their second occasion of a violation. However, for purpose of assessing penalties, WAC 390-37-143 subsection 1 does say that only violations in the last 5 years would be considered for the purpose of determining second and third occasions of a violation for the purpose of penalties. And then I did provide you with a link to the penalty schedule in WAC 390-37-182. And that concludes my presentation. If you have any questions, I am available.
I don't. I am going to find that this committee violated 235 and 240 as described by Ms. Blacksmith in her testimony. I am going to impose a fine of $600. I'm going to suspend 350 of it upon the conditions that all of the reports that are required to be amended and all of the missing reports, as described by Ms. Blacksmith in her testimony, are amended and or filed within 30 days of the issuance of the written order in this case, and that the unsuspended portion of the fine, which is $250, is also paid within that same 30-day period.
Very much.
Do you have any questions about my decision?
Nope. Thank you very much, Commissioner Leach. I appreciate that.
Thank you.
Thank you.
And that takes us to our next hearing.
Right. The next case is for Doug Weiss. It's PDC case number 151234. PDC staff is alleging that Doug Weiss, a 2023 candidate for school director of Clay Elum Roslyn School District 404, violated RCW 4217A 235 and 240 by failing to timely and accurately file C3 reports and C4 reports disclosing contributions and expenditures undertaken by his campaign. Let me see if I can briefly skip through here. I've already indicated he's a candidate for school director in 2023. Election records show there was no candidate filing a fee associated with the position.
Right.
He did file a C1 report or a candidate registration on June 18th of 2023, and he did select the full reporting option. The report was later amended with no changes. That is Exhibit 1. RCW 4217A 235 and 240 do indicate that a candidate that selects full reporting option on their C1 report is required to report contributions and expenditures to the PDC on C3 and C4 reports, and the due dates for those reports are based upon the election cycle, his election participation, and financial activity. As a 2023 candidate participating in the August 1, 2023 primary election, the respondent was required to file the following reports by the following dates. There was a 21-day pre-primary C4 report that was due July 12th of 2023, a 7-day pre-primary C4 report that was due July 25th of 2023, and a post-primary C4 report that was due September 11th of 2023. In addition, if there were any monetary contributions received by the campaign, they would have had to file weekly C3 reports due by the Monday following each deposit made. The respondent did participate in the August 1, 2023 primary election, but did not advance to the general. On April 5th of 2023, we opened a case for the respondent based upon a complaint filed by Connor Edwards, alleging that the respondent failed to provide the required 21-day pre-primary, 7-day pre-primary, and post-primary C4 reports for 2023. That's Exhibit number 2. We did hold a case status review initial hearing for the case on May 13th of 2024. I reached out to the respondent by email on May 30th of 2024 and July 9th of 2024, encouraging him to file the missing reports. I also tried to reach him by telephone. I tried 5 different telephone numbers. On July 24th, I was able to leave 3 voicemail messages. On August 6th of 2024, I did serve the respondent by email and mail with a hearing notice for today's brief adjudicative proceeding concerning his failure to file the required reports for 2023, and the notice was emailed to his personal email address of record and mailed to the address shown on his C4 report, his C1 report, as well as 2 additional addresses, and that's Exhibit number 3. Shortly after I sent that out, the responder's treasurer and spouse, Susie Weiss, contacted the PDC by phone on August 12th of 2024, and she said they had received the hearing notice. She provided her email address and asked me to copy her on future emails, which I did. Ms. Weiss indicated her belief that she had filed the missing reports, and she said she would check the campaign's ORCA account and make sure the reports were filed. She stated the only expenditure they had consisted of an advertisement that Mr. Weiss paid for himself. I did encourage the campaign to file reports and submit a written response to the complaint. And then I sent a follow-up email on August 19th inquiring about the status of the missing reports. Ms. Weiss responded by telephone the next day indicating she was having trouble accessing the campaign's ORCA account. Mr. Weiss emailed the PDC the same day, and our filer assistant staff added Ms. Weiss's email address as an authorized user on the count. So she should be able to go in and make those changes. But as of August 30th, and again today, the respondent has not filed the required pre-election or post-election C4 reports that were due in 2023. Therefore, there are aggravating mitigating and aggravating factors present in this case. A mitigating factor is that the respondent, it does appear to be a first-time candidate, and the campaign appears to be relatively small or unsophisticated. And I couldn't confirm this, but another potential mitigating factor is if the total expenditures were relatively modest, that would be a mitigating factor, but none of that information has been reported, so I'm not able to confirm that. Another factor would be whether the campaign is still experiencing any technical issues. Again, I have not heard from them that that is the case, so that is unconfirmed whether they're still having technical issues. Another aggravating factor is that noncompliance does concern some pre-election reports, so that did deprive the public of timely information during the time-sensitive period prior to the 2023 primary election. And the missing reports as of today have not been filed, so that is an aggravating factor. And there's also one prior occasion of a violation of RCW 4217A 700, which is a different portion of the law that occurred within the last 5 years for failure to timely file a personal financial affairs statement or an F1 report. That was PDC case number 138735. The F1 report was filed late and the case was resolved on July 13th of 2023 by the respondent's submission of a signed statement of understanding and a $100 penalty. That's exhibit number 4. If the presiding officer finds the respondent violated RCW 4217A 235 and 240, at this hearing, it will constitute his first occasion of a violation of 235 and 240. And provided you with the penalty schedule that's present in WAC 390-37182. That concludes my presentation. Thank you.
I'm going to find that there's a violation of 235 and 240 for failure to file reports as described in Ms. Blacksmith's testimony. I'm going to impose a fine of $250 and suspend $100 of it on the conditions that the missing reports are filed within 30 days of the issuance of a written order in this case, and that the unsuspended $150 is also paid within the same 30 days. Do you have any questions about my decision?
I do have a question, and I neglected to mention this in the last hearing.
Sure.
Do you want to include the language that says no, there can be no further violations within the next 4 years?
I don't in these two cases because I don't know that this committee has any ongoing activity in the Bethel case, because you said they hadn't accessed their ORCA account since 2022, which either is totally ignoring the law or they're not currently actively involved in campaigns. This was an unsuccessful first-time candidate. I don't know about any future activity he'll have that involves the PDC, so I don't want to include those conditions because I think that complicates the paperwork from the PDC side in terms of tracking things. It's simpler just to say, no, we didn't get the payment within the 30 days, so the full amount's owed.
Okay, thank you very much.
Thank you.
Commissioner.
All right. And I guess the next thing that will take place is that we will have a public comment from Connor Edwards. Mr. Edwards, are you there?
I am. Thank you, Chair Leach. I just have 3 quick points that I wanted to make about these enforcement hearings. The first point I would make is that the level of penalties that the agency is imposing in cases across the board are not having their desired effect. Just over 50% of the time when this commission issues an order, the respondent does not comply by filing the required report and paying the required fine. Now, part of that is because the penalties that the agency is imposing are too low generally, but specifically the suspended portion of the penalties are too low. Making someone pay another $200 or $300 if they don't comply with the commission's order is simply not that meaningful of an incentive, and that is perceived by many as just the cost of doing business. The other part of that is that the agency is apparently not vigorously pursuing the collection of these penalties. And I don't claim to be a debt collection expert. Maybe there's a reason I'm not aware of, but it certainly seems like it's a problem that needs to be addressed. The second point is that these fines effectively serve as indulgences, and let me explain. Let's say you have a person that simply doesn't want to file an F1 for whatever reason. What would happen is that the staff would bring the case to adjudication. The respondent would get fined probably about $250, and the respondent would just not file the required forms. And the voters wouldn't be able to view the forms prior to voting. And that's not hyperbole. That's something that happens pretty frequently. So my suggestion would be to make the suspended portion of the penalties higher. For instance, if someone is refusing to file an F1, maybe fine them $250 with 750 suspended so that you're giving people a more meaningful incentive to comply with the law. These hearings are the agency's one bite at the apple, so the penalties for noncompliance with the agency's order should be more significant. My final point is that neither of these two respondents were actually fined because they failed to file timely and accurate reports. Every year, there are tons of filers who fail to file C3 and C4 reports by the deadline, and over again, the agency will dismiss those complaints with warning letter after warning letter after warning letter. The agency's de facto policy when handling a complaint relating to late C3 and C4 reporting is to tell the respondent to either file or amend the required reports, even when the election has been over for years. If the respondent simply does this, the agency just dismisses the complaint with a warning letter. Now, if respondents file the required reports after the election, should respondents realize a little bit of a benefit, a little bit of a fine reduction for coming into compliance? Absolutely. But the purpose of disclosure law is for this type of information to be disclosed to the public before the election when the information is meaningful and not after. The agency would never wait to give F1 or C1 filers a chance to file these reports after the election is over without facing penalties for the same obvious reasons. This policy should be extended to C3 and C4 reporters at all. But that's all I've got. So thank you for a chance to speak.
You're welcome, and thank you for your contribution. I think that brings the matters on the calendar today to a conclusion. Is there anything anybody else has to bring forward?
From staff.
For me, thank you.
Okay, thank you, Tabitha.
Thank you, Commissioner. I appreciate all your help today.
Well, I appreciate your good work, and thank you, Kim. And I guess I'll see you 2 weeks from today.
Sounds good.
You want to officially adjourn the meeting?
Oh, thank you, Jordan. I will adjourn the meeting, and you can stop the recording.
Thank you.
Goodbye, all.
Bye.